stating my arguments yesterday, my lord. I am once again, my lord, pointing out to the lordship, my lord, under this particular rule, my lord, the option lies, my lord, with the employee, my lord, to initiate the process of voluntary retirement. As on, my lord, 3/7/2010, on the date, my lord, my application was filed. My lord, within the notice period, they failed to, my lord, pass any order rejecting my application. These are the admitted facts, my lord.
Sir, we are aware. Why you want to repeat?
Like, I'm recapitulating, my lord, my earlier argument, which
Not
I
required.
And so, my lord, if they don't do that, then the VRS is to be automatic, my lord. That is my decision, my lord. I have given another decision also, my lord. 15(2) PLJR, page 625.
Sir, you are relying on circular. Circular will not prevail over rules.
It is not that circular is to prevail, my lord.
Show us from the rules.
These judgments, my lord.
Sir, rule will prevail over the judgment, or judgment will prevail over rule?
The rules, my lord, the rules will prevail, my lord. There is no doubt about it. But the thing is, my lord, it is not in, my lord, violation of the rules, my lord. The circular, which says of 20 years, it is not in violation. Rather, it is harmonizing the my lord, entire thing, which I had read out yesterday to your lordship, my lord. The 5 years will be given as a weightage, my lord, and for another 5 years, my lord, the proportionate pension is to be fixed, my lord. I am not saying the full pension is to be given to me on the basis of and my lord, secondly, I was not even on unauthorized absence as per the order of this honorable court.
Amendment 2, sub rule 3 of rule 74B of VR service code.
This amendment is, my lord, this one has come, my lord, in 12/2/1973, my lord.
Correct, sir. Where is the amendment? Further amendment? Because this rule says that 30 years.
30 years. So, my lord will kindly have a look to the 74A, my lord. My lord is reading 74B1.
So why 74B3 is not applicable?
It is not applicable, my lord.
Correct. What is the reason?
But because the entire, my lord, the privilege given to exercise the option, my lord, it lies under 74(1)B.
Then this is applicable to which cases?
It may be. That period is to be decreased, my lord, by this, which our lordship is pointing out to your lordship.
Correct, sir.
But the thing is, my lord,
Sir,
having completed
which circumstances this rule is operated? 74B3.
That is for my learned friend, my lord, to satisfy your lordship. But so far I am concerned, my lord, I had exercised my option, and as on that day, lord, I was not under suspension. It is the only.
Sir, that is not disputed. Why are you keep on repeating the same?
I am telling, my lord.
We are concerned with whether are you eligible with reference to number of years of service or not.
Yes.
My number of point out that 30 years.
30 years, and my lord, that the circular which has been referred to in these two judgments also, my lord, that circular of
will not prevail over how many times?
Not that, my lord. It is,
all right, we'll consider.
It is not.
All right, sir.
That thing, my lord.
We'll consider your circular.
And I will be getting only proportionate pension. I will not be getting the entire pension, my lord.
No, sir. First of all,
proportionate pension on the basis of the number of years given, my lord.
Council, first of all, your application for VRS is maintainable under Rule 74 or not?
Yes.
If it is maintainable, then what you say? You may say so, but you have to satisfy this code.
Yes, हम बोल रहे हैं कि kindly have a look to this
circular.
No, decision.
Have they interpreted?
Where, my lord, both the things had come for consideration. And after, my lord.
In the decision, have they interpreted 74B3? Show us. In which paragraph?
74B3 is, that was not the occasion.
Therefore, we want to distinguish what is the citation you are cited, that there is no interpretation of 74B3.
Main interpretation of these two rules, my lord, to reconcile it, my lord, is to this effect, my lord, the option lies with the employee. Once he exercises the option, then the state government or the authority have no power at all. Either if I save and accept, my lord, if I am under suspension, only on that account, or they may reject it on other grounds also, my lord, within 3 months. If they don't exercise that within...
Show us from this rule, 74.
Yes, 70...
Read 74 rule completely and point out.
So 74 has got to be read with the circular, my lord, in order to harmonize the things, my lord. Because everywhere 20 years is given here, my lord, that also reconciles about 30 years. It says, my lord, if you file your application after the completion of 20 years,
21 years.
5 years of weightage and 5 years of proportionate pension shall be fixed. It is very categorical, my lord. It is harmonizing. It is not in violation of, my lord. This is my argument for your lordship's kind consideration. That is not...
But we will consider it harmonized.
And I will read out, my lord. I'm lord. I beseech your lordship to read out, my lord.
Why? Yesterday you have read it.
No, this particular judgment. Today I have, my lord, hunted it out, my lord. Yes.
No, whether in that judgment, English paragraph 74 rule has been interpreted.
That was paragraph 54 to 59. Of that 15 का 2 PLJR हुजूर दे दो तो दीजिए हमारे पास है 15 2 PLJR page 625. I just read out. I know my lord thinks loudly, my lord, and is open till the last moment. My lord, we are very aware of your lordship's views. So, my lord, I'll humbly beseech, my lord, to kindly have a look to this paragraph 54 to paragraph 59, my lord. The third case, after, my lord, referring to that 74B1, my lord, thereafter it has been quoted there in paragraph 55. Acha, I'm sorry. It is at page number 648, it starts. 648. Kindly come to page 648.
Yes.
Now 6.48, my lord, paragraph 54 quotes the entire rule 74, my lord, which is subject to, my lord, which is falling for consideration essentially in this particular appeal, my lord. Now, interpreting the scope has been interpreted here in paragraph 55, my lord. Scope of rule, I'm just reading out for your lordship's kind convenience. Scope of rule 74B1, Bihar Service Code has been decided in such and such cases, 2008, 4 PLJR. This is what, my lord, I had yesterday, my lord, pointed out to you. That is also taken into consideration here, wherein it has been held that the option lies with the employee to initiate the proceedings of voluntary retirement. And the only right given to the government is that if the officer is under suspension, such option of the employee for voluntary retirement can be denied. It has further been held that the government could also refuse voluntary retirement only during the notice period, that is 3 months, my lord, of 3 months. Otherwise, it would be deemed retirement on exercise of 3 months notice.
Where is that word? Otherwise deemed?
ये बस वही हम जो पढ़ रहे हैं हुजूर, फिर से हम पढ़ देते हैं हुजूर. It has paragraph 55, my lord, paragraph 55. Shall I read it?
Yeah, read it.
My lord, it has further been held. मिल गया हुजूर. It has further been held that the government could also refuse voluntary retirement only during the notice period of 3 months. Otherwise, it would be deemed retirement on expiry of 3 months notice.
No,
This,
where is the word? In our book, it is not there.
जरूर होगा.
Yes.
मिल गया हुजूर. I am obliged, my lord. This court, आगे पढ़ रहे हैं हुजूर, with the lordship's kind permission. This court, in fact, had taken the aforesaid view in the light of the law laid down by the apex court. And those cases are then reported here, my lord. Yes. Now, paragraph 56, it says, it would be apparent from the reading of the aforesaid judgment of the apex court of this court, provisions of rule 74B1 of the Bihar Service Code, there is no option to the state government to refuse voluntary retirement on any ground except when the government servant has been placed under suspension. In fact, the concept of the concept of approval of the state government comes only where the government servant is under suspension.
Yes.
my point, my lord, and that 20 years which I was reconciling, that has also been taken note of in this, my lord. Paragraph 59 को अब देख लिया जाए.
59, yes.
हाँ, paragraph 59 और paragraph 59 के पहले the circular, my lord, earlier the circular was of 79. It was again reiterated in 2/12/13, my lord. And that is quoted in paragraph 58. And after looking into that circular of 20 years, my lord, this honorable court held, a question would arise that if the petitioner's application dated such and such was kept pending for 15 months, in my case, my lord, it was kept pending for 8 years, my lord, admittedly. 15 months before being rejected. Who is responsible for such delay?
Against this LPA has been filed?
Pardon, my lord?
Against this order, this is single judge order.
This one.
LPA has been filed or not? Already.
To my knowledge, my lord, it has not been. My learned friend can point out. Although, my lord, I hunt out that particular aspect also, whether it has been overruled or not. But to my knowledge, my lord,
take it that there is no LPA.
Lordship. It is a final order, my lord.
Sir, against final order only LPA is filed.
No, I'm sorry, my lord. Finality, it has attained the finality, my lord. That is what I'm trying to. Then, my lord, they say, my lord, then who is responsible for such delay? Secondly, the paucity of teachers. They said, my lord, there is a paucity of teachers. This was also the case of the medical assistant professors, my lord. They said they rejected it on the ground, my lord. A number of medical colleges are not having the assistant professor, so I will not allow you to voluntarily retire. This was the ground, my lord, which was held to be absolutely non-est, my lord. And it was held, my lord, finally, medical college being not a ground referable to the provisions of 74B. Such rejection, in fact, was wholly uncalled for and per se illegal. In the considered opinion of this court, 74B1, जो हुजूर देख रहे हैं, of Bihar Service Code does not brook of any two interpretations. And in fact, this aspect of the matter stands well settled in the line of catena of decisions of the apex court and this court as referred above, that the provisions of voluntary retirement by way of 3 months notice is automatic. My lord, I assert and I emphasize on this, it is automatic.
What used by judge?
Automatic. And the incumbent cannot be refused the privilege of voluntary retirement save and except when he has been placed under suspension. Only one contemplation of the fact, my lord, if he is under suspension.
Sir, how many times you want the same thing, suspension? You think that we are not understanding?
No.
Then why you want to repeat?
That I can never ever.
Right, but don't repeat.
In fact, even pendency of a departmental proceeding and audit objection as per the circular of the department quoted above cannot be made a ground in view of the provisions of 74B1. So, my lord, these are my and my lord, that point of time on 3/7/2010, my lord, whereafter they have inflicted the punishment upon me, my lord, and my lord, that was caused by this honorable court on the basis of the inquiry report, wherein they say, my lord, he was not under unauthorized absence, rather he had given an application for extension of his extension of his leave, my lord. That is also taken into consideration. And finally, it was caused by this honorable court. So that period of 2005 to 2010 cannot be said by any stretch of imagination, my lord, it was a period of this unauthorized absence, my lord. This is my point for your lordship, kind consideration, my lord. I am obliged that your lordship has given me a patient hearing, my lord. Obliged, my lord.
Yes, sir. Principal Secretary. Why there is no assistance from the department? You people don't give information, file to your council? Are you claiming any privilege in respect of any documents? Why you are not providing assistance to the state council?
You have provided all the files.
Show us on what date you are given to the state council.
So we have got all the files.
Just show us, sir, that you have given all the material information to the state council. When did you supply documents to the State Council or Office of the Advocate General?
My lord, in this case, on yesterday,
No, first let him say, on what date you have given papers to the learned State Council or to the Office of the Advocate General for preparation of draft?
Sir, my submission is, sir, whenever the Office of Advocate General or the Standing Council ask for the files, send the deputy persons with the files to his office.
No, in the present case,
Okay, sir,
was there demand by the State Council?
yesterday evening, sir, he
Not yesterday, sir, earlier.
really,
Counter affidavit not filed. Respond. In the repetition. No, in the repetition.
On behalf of this, the affidavit has been filed. In behalf of this community to
From 2010 to 2018, why there is inaction?
So, my lord, in fact, Mr. Kanaya Singh, the medical officer, applied for the VRS. Then
In 2010. What action, why you are not either accepting or rejecting it during the, for about 8 years, 2018?
Sir, after that, we have demanded certain documents from the civil surgeon Madhubani. Since we could not able to get the documents in time, the file was, in fact,
No, why you are not rejected?
2018, sir, it was rejected.
Correct, sir. We are asking you 8 long years you have taken. Who is held responsible? If any financial benefits is required to be given to him from taxpayers' money you want to give because of your lapses? You want in every case judicial order that you are required to do like this, do like this? Then what for you are? Are you not required to exercise powers? Or is he related to some top officials or politicians? 8 long years, what were you doing? Were you sleeping? And rule provides that within 3 months you have to act. Since what date you are holding the post?
Pardon me, sir?
Since what date you are holding the post?
For the last 6 months, sir.
6 months. That is the excuse. And pass on the allegations are on your subordinates. You are not taken any action. Tell us who is going to pay the financial this thing. And if any action is required to be taken against officials, they have already retired. No action under CCA rule, read with Bihar pension rules, 4 years old. This is how you people are functioning. Yes, what is your case? State.
My lord, because as per the provisions laid down under 74, we will be read with 3 below. the qualifying service must supervise on that point 30 years is concerned, Lord. On that point, I may say that supervise previously it was 30 years, thereafter it go down to 25 years, then it has come to 20 years, Lord. Then there must be the qualifying service of 20 years, Lord. So far as petitioner is concerned, he has joined, he has come in the office, in the service.
The appointment was?
His appointment is the year 88, Lord.
Huh?
1988, Lord.
I'm between 88 to 37 2010.
Because he had to remain on duty, my Lord. And he remained absent from the year 2005 to 10, Lord. So up to from 98 to 5, my Lord, it comes hardly of 15 years, Lord.
Then why you did not reject?
That is why it has been rejected, Lord.
Sir, why you did not exercise such power in 2010?
Of course, Lord, some delay has occurred, but it has been rejected, my Lord. Maybe on that very ground, it has been rejected.
After how many years? 8 years.
It has been rejected previously. It was rejected by the Joint Secretary, my Lord, and subsequently, since this matter came to the knowledge of this Honorable Court, Lord, then the direction was given by the Honorable Court to
Condition is required.
Otherwise, in the normal course, he would have retired on what date?
31/7.
so far as the retirement age is concerned, 67 years, so far as doctors are concerned. Doctors are concerned, the retirement.
Sir, otherwise, we are asking you, please understand the question. Otherwise, in the normal course, on what date he would have retired?
68.
2027, my Lord.
What is the date?
31/1/2027, 27, my Lord.
27.
My Lord.
Are you going to regularize and pay the all the amount from 2010 to 2023?
27.
No, as on today, you have to give. Not you want.
No.
You want to have luxurious litigation. Are you going to pay? Then how do you overcome? Easy to say a word, no. How do you overcome? All right, according to you, you have rejected. He is entitled to service. He want to continue till 27. Up to 2023, he is entitled to arrears and other things.
There was no qualifying service, you are not found on duty.
All right, sir, he will continue. Assuming that he will continue. Are we going to settle his monetary benefits?
And for that very purpose, now the departmental person was.
Even that he has suffered. Order before this court. Because of every stage, there is inaction on your part.
My Lord, the departmental first departmental proceeding is concerned, but although it was quite true, but again it has been again he remained absent. No, that is why again the departmental proceeding has been stated the charge.
Why you are not suspended him? You have a powers or not? First, you suspend principal secretary, health department. Go and suggest to the chief minister. Suspend the principal secretary. There is inaction in the each and every stage from 2010, 3/7/2010 to even to this day. Why taxpayers' money is being wasted like this?
Now the inquiry is complete, my Lord.
All right, sir, what are you going to do? If inquiry is completed, how are you going to regulate from 2010 to 2023? Instead of better get rid of that officer with effect from 3/7/2010 in order to save your skin, and so also financial benefits can be curtailed.
My Lord, may consider so far as initiation of departmental proceeding concerned, Lord, the suspension is not required. It may be, he may be put on a suspension, he may not be put under suspension, Lord. For departmental proceeding concerned, that has been initiated, the charge memo was issued, Lord, he has filed his written statement of defense, Lord. Now the inquiry is complete, Lord. The second so-called is going to be issued, Lord. And final decision.
Till 27, don't take any action. He will retire. Bless him. What to do?
Correct, but belated. How to regulate the intervening period from?
Till today, he is dismissed person.
Huh?
Till today, he has all been dismissed and still he
He has been dismissed. On what date?
23.
2023. Yesterday.
23. That is what I pointed out.
आप जब बोल रहे थे हम चुप थे ना, आप उठिए ना.
हमसे पूछ रहे हैं तो हम बोल रहे हैं. वो कोशिश करने की बात.
What is the date of dismissal? 20. Give the date. We don't want.
12/1/23 मिलो. 12/1/23. तैयार रहिए.
On 13/1/2021. 21.
What is the date of charge memo?
The charge member was 9. Nine 10/2009. 9/10/2009.
9/10/2009.
For which spell? Unauthorized absence.
For authorized absence from the year 2005 to 10.
Sir, that has attained finality. We are asking you second spell.
Second spell is concerned, Lord. It has been the charge memo has been
Penalty, no?
10/8
Have imposed the penalty. Yes. Yeah, fine. That is the reason yesterday we are asking him, not giving the date.
I am giving the date, my Lord. This is on 10/8/2018, my Lord.
10/8?
10/8/2018, my Lord.
No, sir. The initiation of charge memo
My Lord.
for second spell.
Second spell.
What is the date?
10/8/2018, my Lord.
18.
My Lord.
So you have waited for 8 years to initiate inquiry. No, why all action is taken in the year 2018? It could have been taken in 2027 when we have waited for 8 long years.
Now he has already submitted a statement of defense, Lord. The inquiry is complete.
Have you charged the charge memo? Have you questioned the charge memo?
I'm the separate writ application I have filed, my lord.
No, sir, challenge the charge memo, saying initiation of inquiry, second inquiry. Then how can you take contention that it is a deemed acceptance?
It was never served upon me. It is for the first time that this, my lord, 23 dismissal order was, my lord, through the press communique. I have brought this on the record, my lord. How they have done the things, my lord. And initially they were to proceed against Rule 17, my lord.
No, charge memo was not issued to you.
Never, no charge memo, no notice, no show cause, nothing.
Charge memo has been issued, my Lord. Notice has been.
Because that it has been served on him.
So, what has happened in this case, Lord?
Sir, show us that he has been served. Because we want to overcome his contention that it is a deemed acceptance.
He has already, even he has also appeared in that proceeding, my lord. And now he is, my lord.
Some material. No, it's not challenge. He cannot now contend as that is a deemed acceptance of VRS.
Now, on
And right-
28/9/2018, he has submitted his defense of statement of defense, my lord.
Right after 10 after 3
28 now.
challenge my VR deemed to charge memo.
On 28/9/2018, even the written statement of defense has also been submitted by him, my lord. अट्ठाईस नौ अठारह 28/9/18
पार्टिसिपेटेड and उनका साइन भी है संचार ये आरोपित करने से पार्टिसिपेट
I will read out Hindi, thereafter I will translate into Urdu. न्याय पक्ष उपस्थित आरोपित चिकित्सा पदाधिकारी द्वारा कल 24/4/18 को लिखित बचाव बयान साक्ष्यों उपरांत साक्ष्य समर्पित किया जाता है। संख्याबद्ध कीजिए। So on 28/9/2018, Lord, he appeared, Lord, he has submitted his statement of defense.
What is the date of his submission of explanation to the charge memo?
28/9/2018.
Explanation.
Can you give the date only?
28/9/2018.
28/9/2018 he filed this written.
Explanation.
He has appeared, it is also signed in the order by him, Lord.
Sorry. Now we cannot contend that my VRS.
And on the same date, he has submitted the written statement of defense. He has signed the order in order sheet, Lord.
We should not challenge.
My lord may verify from the record, we are the record.
We don't want. But to this banks in there. Yes. Was eligible. Not eligible. For points of years. Pursuant to our previous order, Mr. So and so is present in the court. A very pertinent question was posed to him as to what action has been taken by the department / officials of the concerned officials during the intervening period from 3/7/2010 8/2018 relating to voluntary retirement application of the appellant. So there is no answer except saying that appellant was subjected to disciplinary proceedings for remaining unauthorized absence during the intervening period from 2005 to 2010 and was punished. and it was a subject matter of litigation before this court. Order of punishment has been set aside. Thereafter, for remaining unauthorized absence, further period from the month of July 2010 to 2018 till the rejection of application of VRS dated 3/7/2010, the department presumed that petitioner remained unauthorized absence and proceeded to initiate action in the year 2018 after lapse of 8 years. To perusal of the records, it is evident that each and every stage there is a serious lapse on the part of the officials of the concerned department in not taking timely action